Welcome to UPSC IMP. New topic: jurisdiction and power of the Supreme Court. The Constitution has confirmed very extensive jurisdiction and vast power on the Supreme Court. It is not only a federal court like the American Supreme Court, but also a final court of appeal like a British House of Lords, upper house of the British Parliament. It is also the final interpreter and guardian of the Constitution and guarantor of the fundamental rights of the citizen. Further, it has advisory and supervisory power. The jurisdiction and power of the Supreme Court can be classified into the following: appellate jurisdiction. As I mentioned earlier, the Supreme Court has not only succeeded the Federal Court of India but also replaced British Privy Council as the highest court of appeals. The Supreme Court is a preliminary court of appeal and hears appeals against the judgment of the lower courts. It enjoys a wide appellate jurisdiction which can be classified under four heads: appellant in constitutional matter, appeals in constitutional matter, appeals in civil matters, appeals in criminal matters. Supreme Court hears appeal against the judgment in the criminal proceedings of the High Court if the High Court has an appeal reverse on an order of acquittal of the accused person and sentenced to him to death, or has taken before itself any case from any subordinate court and convicted the accused person and sentenced him to death, or certify that case is fit for appeal to the Supreme Court. In the first two cases, the appeal lies to the Supreme Court as a matter of right without any certificate of the High Court. But if the High Court has reversed the order of the conviction and has ordered the acquittal of the accused, there is no right to appeal to the Supreme Court. Appeals by special leaves. The Supreme Court is authorized to grant in its discretion special leave to appeal from any judgment in any matter passed by any court or tribunal in the country except military tribunal and court martial. This provision contains four aspects as under: it is a discretionary power and hence cannot be claimed as a matter of right. It can be granted any judgment, whether final or interlocutory. It may be related to any matter: constitutional, civil, criminal, income, tax, labor, revenue, advocates, etc. It can be granted against any court or tribunal and not necessarily against High Court, of course, except a military court. Thus, the scope of this provision is very wide and it vests the Supreme Court with plenary jurisdiction to hear appeals. On the exercise of this power, the Supreme Court itself held that being an exceptional overriding power, it has to be exercised sparingly and cautions and only in special extraordinary situations. Beyond that, it is not possible to fetter the exercise of this power by any set formula or rule. Advisory jurisdiction. The Constitution, Article 143, authorizes the President to seek the opinion of the Supreme Court in two categories of the matter: on any question, law, or fact, the public importance which has arisen or which is like to be arise; on any dispute arising out of any pre-constitutional tragedy, agreement, convents, engagement, sanad, or other similar instrument. In the first case, the Supreme Court tender or may refuse to tender its opinion to the President. But in the second case, Supreme Court must tender its opinion to the President. In both the cases, opinion expressed by the Supreme Court is only advisory, not judicial pronouncement. Hence, it is not binding on the President. He may follow or may not follow the opinion. However, it facilitates the government to have an authoritative legal opinion on the matter to punish for contempt not only of itself but also high courts, subordinate court, and tribunal functioning in their entire country. Power of judicial review. Judicial review is the power of the Supreme Court to examine the constitutionality of the legislative enactment and executive order of both the central and state government. On the examination, if they are found to be violative of the Constitution ultra vires, they can be declared illegal, unconstitutional, and invalid, null and void by the Supreme Court. Consequently, they cannot be enforced by the government. Constitutional interpretation. The Supreme Court is the ultimate interpreter of the Constitution. It can be given the final version of the spirit and content of the provision of the Constitution and the verbiages used in the Constitution. While interpreting the Constitution, the Supreme Court is guided by the number of doctrines. Other powers. Besides the above, the Supreme Court has numerous other powers. It decides the disputes regarding the election of the president and vice president. In this regard, it has the original, exclusive, and final authority. It inquires into the conduct and behavior of the chairman and member of the Union Public Service Commission on references made by the president. If it finds them guilty of misbehavior, it can recommend to the president for their removal. The advice tendered by the Supreme Court in this regard is binding on the president. It has the power to review its own judgment or order. Thus, it is not bound by its previous decision and can be depart from it in the interest of the justice or community welfare. In brief, Supreme Court is self-correcting agency. For example, in the Keshwananda Bharti case 1973, the Supreme Court departed from its previous judgment in the Golaknath case in 1967. It is authorized to withdraw the cases pending before the High Court and dispose them by itself. It can also transfer the cases or appeals pending before the one High Court to another High Court. Its law is binding on all the courts in India. Its decree or order is enforceable throughout the country. All the authorities, civil and judicial in the country, should act in aid of the Supreme Court. It has the power of judicial superintendence and control over all the court and tribunal function in the entirety of the country. Supreme Court jurisdiction and the power with respect to matter in the union list can be enlarged by the Parliament. Further, its jurisdiction and power with respect to other matter can be enlarged by special agreement between the center and state. New topics. First mover coalition is a global initiative harnessing the purchasing power of the company to decarbonize 7 and hard to abate industry sector that currently account for 30% of the global emission: aluminium, aviation, chemicals, concrete, shipping, steel, trucking, along with the innovative carbon removal technologies. The 50 plus companies who make up the coalition seeks to send a powerful market signal to commercialize zero carbon technology. The first mover coalition unique approach assembles the ambitious corporate purchasing pledge across the heavy industry and long distance transport sector, responsible for a third of the global emission. For this sector decarbonize at the speed needed to keep the planet on 1.5 degree pathway, they require low carbon technologies that are not yet competitive with current carbon intensive solution but must reach commercial scale by 2030 to achieve the net zero emission globally by 2015. To jump start the market, the coalition member commit its advance to purchasing the proportion of the industrial material and long distance transportation they need to form suppliers using the near zero or zero carbon solution dissipate the premium cost. India participated in the first mover coalition leadership meeting of the World Economic Forum, which deliberated on the world need for clean energy technology to confront the climate crisis globally. Industry leaders appreciated India's fight against the COVID, leveraging digital technology, and also expressed their appreciation for the government partnering with industry in its flight. New topic. The organization structure, jurisdiction, and nomenclature of the subordinate judiciary are laid down by the state. Hence, they differ slightly from the state to state. For example, at lowest level on the civil side is the court of municipal and other criminal sides. is the court of judicial magistrate. The municip possesses a limited judicial and decides the civil cases of the small pecuniary stakes. The judicial magistrate tries the criminal cases which are punishable with imprisonment term up to 3 years. In some metropolitan cities, there are city civil courts, chief judge on the civil side, and the court of metropolitan magistrate on the criminal side. The Panchayat court function in civil and criminal areas under various regional names like Nyay Panchayat, Panchayat Adalat, Gram Kacheri, etc. Municipal courts are next level civil courts, the jurisdiction of which are determined by the High Court. Above the municipals are subordinate judges who have unlimited pecuniary jurisdictions and act as the first appeal for municipal. New topic. Recently, Madhya Pradesh has notified its PESA rules on the occasion of the Janajati Gaurav Divas on 15 November 2022. At the state level, Janajati Gaurav Divas Sammelan at Shahadol in Madhya Pradesh. Governor of Madhya Pradesh Sri Mangu Bhai Patel handed over the first copy of the Panchayat Extension to Scheduled Area Act PESA Act manual to the President of India Srimati Draupadi Murmu. The provision of the Part 9 of the Constitution relating to the Panchayat are not applicable to the 5th scheduled areas. However, the Parliament may extend these provisions to the such areas subject to such exception and modification as it may be specified. Under this provision, the Parliament enacted the provision of the Panchayat Extension to the Scheduled Area Act 1996, popularly known as the PESA Act or Extension Act. Presently, 10 states viz. Andhra Pradesh, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha, Rajasthan, Telangana have 5th scheduled area in their respective state. Presently, 10 states Andhra Pradesh, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha, Rajasthan, Telangana have 5th scheduled area in their respective state. Out of the 10 PESA states, 8 states namely Andhra Pradesh, Chhattisgarh, Gujarat, Himachal Pradesh, Maharashtra, Madhya Pradesh, Rajasthan, Telangana have framed and notified their state PESA rules under the respective state Panchayati Raj Act. 9 PESA states except Rajasthan have incorporated the provision of the PESA in 1996 in their respective state Panchayat Raj Act. The 10th state Rajasthan has notified the Rajasthan Panchayat Raj modification of the provision in their application to the Scheduled Area Act 1999. New topic. Prime Minister advised the President with regard to the appointment of the important official like Attorney General of India, Comptroller Auditor General of India, Chairman and member of the UPSC, Election Commissioner, Chairman and member of the Finance Commission, and so on. Article 280 of the Constitution of India provides for the Finance Commission as a quasi-judicial body. It is constituted by the President of India every 5th year or at such earlier time as he considers necessary. The Finance Commission consists of the Chairman and 4 other members to be appointed by the President. They hold office of such a The Finance Commission consists of the Chairman and 4 other members to be appointed by the President. They hold office for such a period as specified by the President in his order. They are eligible for reappointment. The Election Commission shall consist of the Chief Election Commissioner and such a number of other election commissioners, if any, as the President may from time to time fix. The appointment of the Chief Election Commissioner and other election commissioners shall be made by the President. The Constitution Article 76 as provided for the office of the Attorney General of India. He is the highest law officer in the country. The Attorney General is appointed by the President. In addition to the Attorney General, there are other law officers of the Government of India. They are Solicitor General of India and additionally Solicitor General of India. They assist Attorney General in the fulfillment of his official responsibility. It should be noted here that only the office of the Attorney General is created by the Constitution. In other words, Article 76 does not mention about the Solicitor General and additional Solicitor General. The Solicitor General of India is appointed to assist the Attorney General along with the four additional Solicitor General by the appointment committee of the cabinet. The proposal for the appointment of the Solicitor General, additional Solicitor General, is generally moved at the level of the Joint Secretary, Law or Law Secretary in the Department of the Legal Affairs, and after obtaining the approval of the Ministry of Law and Justice, the proposal is sent to the appointment committee of the cabinet for its approval. New topic. In each house of the parliament there is a leader of opposition. The leader of the largest opposition party have not less than 1/10 seats of the total strength of the house is recognized as the leader of the opposition in that house. In parliament system of the government, the leader of the opposition has significant role to play. His main function are to provide a constructive criticism of the policies of the government and to provide an alternative government. Therefore, the leader of the opposition in the Lok Sabha and Rajya Sabha were accorded statutory recognition in the 1977. They are also entitled to salary, allowances and other facilities equivalent to that of the cabinet ministry. New topic. Supreme Court advocate. Three categories of the advocates are entitled to practice a law before the Supreme Court. They are senior advocates. These are the advocates who are designated as a senior advocate by the Supreme Court of India or by any high court. The court can be designated any advocate within his consent as a senior advocate if in its opinion, by virtue of his ability, standing at a bar or special knowledge or experience in the law, said advocate is deserving of such a distinction. A senior advocate is not entitled to appear without an advocate on records in the Supreme Court or without junior in any other court or tribunal in India. He is also not entitled to accept the instruction to draw a pleading or affidavits, advise on evidence, or do any drafting work of an analogous kind in any court or tribunal in India, or undertaken convincing work of any kind whatsoever, but this prohibition shall not extend to settling any such a matter as aforesaid in a consultation with the junior advocates on record. Only these advocates are entitled to file any matter or document before the Supreme Court. They can also file an appearance or act for a party in the Supreme Court. Other advocates. These are the advocates whose names are entered on the roll of any state bar council maintained under the Advocates Act 1961, and they can appear and argue any matter on behalf of party in a Supreme Court, but they are not entitled to file any document or matter before the court. New topic. Next new topic. The maximum strength of the Rajya Sabha is fixed at 215, out of which 238 are to be representatives of the state and union territories elected indirectly, and 12 are nominated by the president. At the present, Rajya Sabha has 245 members. Of these, 229 members represented state, 4 members represented the union territories, and 12 members are nominated by the president. Fourth schedule of the Constitution deals with the allocation of the seats in the Rajya Sabha to the states and union territories. Representation of the state. The representatives of the states in Rajya Sabha are elected by the elected member of the State Legislative Assembly. The election is held in accordance with the system of the proportional representation by means of the single transferable vote. The seats are allotted to the states in the Rajya Sabha on the basis of the population. Hence, the number of the representatives varies from state to state. For example, Uttar Pradesh has 31 members while Tripura has 1 member only. However, in the USA, all the states are given equal representation in the Senate irrespective of their population. USA has 15 states and the Senate has 100 members, 2 from each state. Representation of the union territories. The representation of the each union territory in Rajya Sabha are indirectly elected by members of the Electoral College, specially constituted for the purpose. This election is also held in accordance with the system of proportional representation proportional representation by means of the single transferable vote. Out of the 9 union territories, only 3, Delhi, Pondicherry, Jammu Kashmir, have representation in the Rajya Sabha. The population of the other 6 union territories are too small and to have any representation in the Rajya Sabha. Nominated member. The president nominates 12 members to the Rajya Sabha from the people who have special knowledge or practical experience in art, literature, science, social service. The rationale behind this principle of the nomination is to provide eminent persons a place in the Rajya Sabha without going through the process of the election. It should be noted here that American Senate has no nominated member. New topic. Composition of the counseling. Article 171. Unlike the member of the Legislative Assembly, the member of the Legislative Council are indirectly elected. The maximum strength of the council is fixed at 1/3 of the total strength of the assembly, and the minimum strength is fixed at 406. It means that size of the council depends on the size of the assembly of the concerned state. This is done to ensure the predominance of the directly elected House Assembly in the legislative affairs of the state. Though the Constitution has fixed the maximum and minimum limits, the actual strength of the council is fixed by the Parliament. Manner of the election. Of the total number of the member of the Legislative Council, 1/3 are elected by the member of the local bodies in the state like municipality, district board, etc. 1/12 are elected by graduate of 3 years standing and residing with the state. 1/12 are elected by the teachers 3 years standing in the state, not lower in the standard than the secondary school. 1/3 are elected by the member of the legislative assemblies of the state from amongst the persons who are not a member of the assembly, and the remainder is nominated by the nominated by the governor from the person who have special knowledge or practical experience of literature, science, art, cooperative movement, and social service. Thus, 5/6 of the total number of the member of the legislative council are indirectly elected, and 1/6 are nominated by the governor. The members are elected in accordance with the system of proportional representation by means of single transferable vote. The bona fide or property of the governor nomination in any case cannot be challenged in the court. This scheme of the composition of the Legislative Council as laid down in the Constitution is tentative, not final. The Parliament is authorized to modify or replace the same. However, it has not enacted any such a law so far. New topic. The Metropolitan Planning Committee is established by the Article 243 ZE of the Constitution. Every metropolitan area shall have the Metropolitan Planning Committee to prepare a draft development plan. The state legislature may make a provision with respect to the following. The composition of such a committee, the manner of the election of the member of such a committee, the representation in such a committee of the central government, state government, and other organization, the function of such a committee in relation to planning and coordination for the metropolitan area, the manner of the election of the chairperson of such a committee. The Act laid down that 2/3 of the member of the Metropolitan Planning Committee should be elected by the elected member of the municipalities and chairperson of the Panchayats in the metropolitan area from among themselves. The representation of these members in the committee should be in the proportion to the ratio between the population of the municipalities and the Panchayat in that metropolitan area. Chairperson of such a committee shall forward the development plan to the state government. In preparing the draft development plan, a metropolitan planning committee shall have regard to the plan prepared by the municipalities and panchayat in the metropolitan area. Matter of the common interest between the municipality and panchayat, including coordinated spatial planning of the area, sharing of water and other physical and natural resources, integrated development of the infrastructure, and environment conservation. The overall objectives and priorities set by the government of India and the government of the state. The extent and nature of the investment likely to be made in the metropolitan area by the agency of the government of India and the government of the state and other available resources, whether financial or otherwise. Also, Metropolitan Planning Committee shall consult such an institution and organization as the governor may specify. New topic. Governor can promulgate ordinance when the state legislature is in not session. The ordinance must be approved by the state legislature within 6 weeks from its reassemblies. He can also withdraw an ordinance anytime. This is the most important legislative power of the governor. He cannot make an ordinance without the instruction from the president in the three cases. If a bill is containing same provision would have required the previous sanction of the president for its introduction into the state legislature. If he would have deemed it necessary to reserve a bill containing the same provision for the consideration of the president. If an act of the legislature of the state containing the same provision would under this constitution have been invalid unless having been reserved for the consideration of the president it had received the assents of the president. New topic. Article 72 of the Constitution empower the President to grant a pardon to persons who have been tried and convicted of any offences in all cases where the punishment or sentence is for an offences against the union law. Punishment or sentence is by a court martial or military court. Sentence is sentence of death. The parodying power of the president is independent of judiciary. It is an executive power, but the president, while exercising this power, does not sit as a court of appeal. The parodying power of the president includes the following. Pardon removes both sentence and conviction and completely absolves the convict from all the sentence, punishment, and disqualification. Commutation denotes substitutions of one form of punishment for a lighter form. For example, a death sentence may be commuted to rigorous imprisonment, which in turn may be commuted to a simple imprisonment. Remission implies reducing the periods of the sentence without changing its character. For example, a sentence of rigorous imprisonment for 2 years may be remitted or rigorous imprisonment for 1 year. Recipient denotes awarding a lesser sentence in place of one originally awarded due to a special fact such as the physical disabilities of the convict or the pregnancy of the woman offender. Reprieve implies the stay of the execution of the sentence, especially that of the death penalty or temporary period. It proposes is to enable the convict to have time to seek a pardon or commutation from the president. New topic. Independence of the Supreme Court. The Supreme Court has been assigned a very significant role in the Indian democratic political system. It is a federal court, the highest court of the appeal, guarantor of the fundamental rights of the citizen, and guardian of the Constitution. Therefore, its independence becomes very essential for the effective discharge of the duties assigned to it. It should be free from the encroachment, pressures, and interferences of the Executive Council of Ministers and the Legislature Parliament. It should be allowed to do justice without fear or favor. The Constitution has made the following provision to safeguard and ensure the independent and impartial functioning of the Supreme Court. Mode of the appointment. Judge of the Supreme Court are appointed by the President, which means the Cabinet, in consultation with the member of the judiciary itself, Judge of the Supreme Court and the High Court. This provision curtails the absolute discretion of the executive as well as ensures that judicial appointments are not based on any political or practical consideration. Security of tenure. Judge of the Supreme Court are provided with a security of tenure. They can be removed from office by the President only in the manner on grounds mentioned in the Constitution. This means that they do not hold their office at the pleasure of the President, though they are appointed by him. This is obvious from the fact that no judge of the Supreme Court has been removed or impeached so far. Fixed service condition. The salary, allowance, privileges, leaves, and pensions of the judge of the Supreme Court are determined from time to time by the Parliament. They cannot be changed to their disadvantages after their appointment except during the financial emergency. Thus, the condition of the service of the judge of the Supreme Court remain the same during their term of office. expenses charged on consolidated fund. Salary, allowances, and pension of the judge and staff, as well as administrative expenses of the Supreme Court, are charged on the Consolidated Fund of India. Thus, they are non-votable by the Parliament, though they can be discussed by it. The conduct of the judge cannot be discussed. The Constitution prohibits any discussion in the Parliament or the state legislature with respect to conduct of the judge in the Supreme Court in discharge of their duties, except when impeachment motion is under consideration of the Parliament. Ban on practice after retirement. Retired judges of the Supreme Court are prohibited from pleading or acting in any court or before any authority within the territory of India. This ensures that they do not favor anyone in the hope of future favor. Power to punish for its contempt. Supreme Court can punish any person for its contempt. Thus, its action and decision cannot be criticized and opposed by anybody. This power is vested in the Supreme Court to maintain its authority, dignity, and honor. Freedom to appoint its staff. Chief Justice of India can appoint officers, servants of the Supreme Court without any interference from the executive. He can also prescribe their condition of the service. Its jurisdiction cannot be curtailed. Parliament is not authorized to curtail the jurisdiction and power of the Supreme Court. The Constitution has guaranteed to the Supreme Court jurisdiction of the various kinds. However, the Parliament can extend the same. Separation from executive. The Constitution directs the state to take steps to separate the judiciary from the executive in the public service. This means that the executive authority should not possess judicial power. Consequently, upon its implementation, the role of the executive authority in judicial administration came to an end. New topic. Judicial power and the function of the governor are: he can grant a pardon, reprieve, recipient, remission of the punishment, suspend, remit, commute the sentence of any person convicted of any offences against any law related to a matter to which executive power of the state extends. He is consulted by the President while appointing the judge of the concerned state high court. He makes appointment, posting, promotion of the district judge in the consultation with the state high court. He also appoints a person to judicial service of the state other than the district judge in consultation with the state high court and the state public service commission. Appointment of the judge of the high court. Judge of the high court are appointed by the president. The chief justice is appointed by the president after consultation with the chief justice of India and the governor of the state concerned. For the appointment of the other judge, Chief Justice of the concerned High Court is also considered. In case of the common High Court for two or more states, the governor of all the state concerned are consulted by the President. The appointment, posting, and promotion of district judge in the state are made by the governor of the state in consultation with the High Court. Thank you so much.